गुड इवनिंग ऑल। आज का जो सब्जेक्ट है वो 2019 में अमेंडमेंट क्या हुई थी कोऑपरेटिव हाउसिंग सोसाइटी में, स्पेशल फॉर महाराष्ट्र, उसके लिए है। वी हैड फर्स्ट लेक्चर ऑफ द बायलॉज ऑफ द जो कोऑपरेटिव हाउसिंग सोसाइटी है. इट वाज अ वेरी गुड रिस्पांस एंड दिस मोटिवेटेड अस फॉर द सेकंड सेशन ऑफ द सेम बायलॉज बट विद सम अमेंडमेंट्स व्हिच वी कैन आज इसरानी सर वो पूरा नॉलेज इंपार्ट करेंगे एंड वी ऑल विल बी बेनिफिटेड. हम लोग जो घर बनाते हैं जिंदगी में इसलिए बनाते हैं कि हमारी अगली पीढ़ी को संघर्ष नहीं करना पड़े, स्ट्रगल नहीं करना पड़े. लेकिन कई बार ऐसा होता है कि जो अगर हमारी डेथ हो जाती है या फैमिली मेंबर की डेथ हो जाती है जिसके नाम पर घर होता है, उसके ट्रांसफर के जितने इश्यू होते हैं, जो सोसाइटी में हम लोग रहते हैं कई सालों से दोस्त की तरह, फैमिली मेंबर्स की तरह, वहां हम लोग दुश्मन बन जाते हैं. अचानक हमको कमेटी वाले, चेयरमैन, सेक्रेटरी वो हमें दुश्मन प्रतीत होते हैं because they are not transferring, but sometimes there is a lack of the proper understanding of the law, which is not that knowledge is not available to everybody. So this lecture is the series to understand that laws better and to avoid all this confusion in the future. Now I am requesting Amit Israni sir, who is an expert in this, to start the subject for today. And over to you, Amit sir.
Good evening, madam. Good evening, all.
Good evening.
Good evening. Now, I will take the lecture from a different point of view. There has been many amendments in the Cooperative Society Act since 2013. We have had amendments, we have had ordinances, and then we have had Amendment Act 2019. The biggest problem that happens is when people look at the bylaws, they find that bylaws are talking about the same subject in a different manner, but the act which has been amended speaks of the same subject in a different manner. And in order to remove this confusion, we have to understand one or two things. Bylaws are an agreement between the flat owners in a particular society, and they are applicable to them. And the act is applicable to the whole of the country and the whole of the world when they are dealing with a particular society or any other society. If there is a bylaw which states certain things and the act is changed, we don't have to amend the bylaw compulsorily. The act is superior, the rules are superior, so they supersede the bylaws. So even though the bylaws may state certain things, it is the act which supersedes and the act has to be followed. And at that time, the bylaws have to be read together with the act. Now there's a section in the act which is 154B2, which is the new chapter which has come in the 2019 amendment, where certain definitions have been given. Now these definitions have got something different from the bylaws. So that is why it is important that we look at some of these definitions, which I will take you through today, and show you the difference between the bylaws and the same subject in the act, and what is in the act will supersede and has to be followed. The first item which we find in the new act is the word allottee. In the bylaws, the word allottee does not appear, and therefore we have this problem about who is an allottee. When the builder sells you a flat, you are an allottee, but when you join the society, you become a member. So the word allottee has been brought into the Cooperative Society Act for the first time, and the definition is also given, which is in sync with RERA. So now the definition of allottee in RERA and the allottee in the Cooperative Society Act is similar, so they are matching. So there is no confusion in the words allottee. When somebody buys a flat from the builder and you are not a member, you are an allottee. And then when you become a member, you convert from allottee to member. So this is the first change that has come in. The second change that has come in is where there are multiple societies in one compound or one plot of land, and there is something called Federation of Societies which are formed. Under the 2019 Act, a slight difference in the nomenclature has been brought forward. So previously we used to call the group of societies as a federation of societies. Now they've changed that to association of societies because the word federation was causing a confusion between the federation of 5 buildings or the housing federation, which is the apex body of the Federation of Cooperative Societies. So in order to remove the confusion, the name that has now come in is Cooperative Societies, Association of Societies. And to register an association, you need 5 societies, which is the same law as before. So 5 societies can or more can get together to make an association of societies where they can take care of the common areas, they can take care of the conveyance, they can take care of all their society issues. Another problem that was being faced was if in a building there are 4 societies and there is a clubhouse, which some builders used to register separately as a company because they wanted to control it. So we had 4 societies and separate body, which is your clubhouse or amenities or whatever it might be. Or you might have a situation where a person buys over a whole building from the builder and he registers it as a company. So you have in one compound 4 societies and one company. Or you may have in a compound where you have one society and a company because you can register the building as a company as well. Then how do you form a federation? So to resolve that problem, the amendment brought about an item called Cooperative Housing Association. Now, this is an association of housing societies and other legal bodies. The Association of Societies is only societies, whereas the Cooperative Housing Association is an association of housing societies and other legal bodies for the purpose of maintaining common amenities or conveyance, because that company will be on the same land, which the society is also occupying. And society gets a conveyance, the company will not be able to get it because the procedure would be different. So to surmount that problem, the Cooperative Housing Association nomenclature was created. And this is for maintaining the common amenities or conveyance of land and respect of the plot or layout. So these are the 2 important nomenclature changes that have happened, which everybody must understand because they don't appear in the bylaws. Next thing that has come in is promoter. Now we have had many situations where the word promoter has been confused with builder promoter or chief promoter of cooperative society or promoter of cooperative societies. So there are 3 times that these words were being used in different acts. Under RERA and MOFA, we had promoters who built the building, and in Cooperative Society Act, we had promoters who formed the society. So there was a big confusion, and many times we found that the builder becomes the chief promoter himself and then tries to register society because he's being defined as a promoter. So to remove that difference, because the promoter can only be somebody who has a flat. If you don't have a flat in the building, you cannot be a chief promoter of a cooperative society. Because before you start the process of the formation of the cooperative society, you
चलो अभी मैं करूँ ना
उनको नहीं खेल रहा
सर अब कंटिन्यू कीजिए, मैं म्यूट कर रही हूँ, अब कीजिए, कंटिन्यू कीजिए. So your voice is not audible, sir.
Yes, I was also muted, so now I'm okay. Thank you. All right. So now we have 3 promoters: builder promoter, promoter, and chief promoter. So whenever the society is to be formed, it has to be formed by the buyers of the building because they are the people who are going to run the society. Builder remains a promoter because he's got some unsold flats. So that was the confusion which is sought to be removed. And we have now under Cooperative Societies Act, something called builder promoter, which is the same definition which syncs with RERA, so no confusion. Then we have chief promoter, who is the one who has to form the society. And then we have the promoters, who are the other people, members or buyers, let me put it, who join in with the chief promoter because we need minimum number, and they become promoters to form the society. So this clears now with the 3 definitions, because in our bylaw, these definitions may not be found in the 2014 bylaw. which is the latest bylaw that has been put up in the registrar's commissioner's website. Now we come to the next point, which is member. The question is, who is the member? So in the new definition, the explanation given is slightly different from what appears in the bylaw. In the definition in the Act, it says member means a person joining in an application for registering a housing society. Now, at that point, it is the allottee who then becomes a member. That is why the definition of allottee has been given and the definition of member has been also given. So, allottee is somebody who is allotted the flat by the builder or by the society when it is a self-redevelopment. And then we have members is a person joining in an application for registering a housing society, which is subsequently registered, or now there is a second type of member as well, which everybody is aware of, or a person duly admitted to a member of a society after its registration and includes associate, joint, or provisional members. Now, these are three new names that have come up in the Act. They don't appear in the bylaws. So there is a confusion that when you go to the bylaws, it defines associate member as somebody who has an interest in the property. Whereas in the Amendment Act of 2009, it says that anyone who joins after registration and includes an associate, joint, or provisional member, which means the associate member need not be having an interest in the property. So this is a very, very major difference that has happened between the Act and the bylaws. And bylaws have to be read together with the Act. And one more issue that I want to clarify is every society has a separate bylaw. Maybe you all are not aware that this bylaw which is applicable to your society is the one which is registered with the registrar, approved and registered with the registrar. So if somebody has registered the 2009 bylaw, somebody has registered the 2061 bylaw, or 1961 bylaw, sorry. Somebody has registered the 2014 bylaw. Somebody has registered the 2006 bylaws. Then all the bylaws would stand amended by an operation of law by virtue of the amendment in the Act, and the Act will supersede all such clauses which are not synchronized with the Act. So there should be no confusion on that point. I'll take questions on this later if somebody needs clarification. They can put the questions in the chat form. Madam, you can ask them to put in the chat form so that Madam can take up the questions at the end and I can clarify.
I've noted.
Yeah, so they can start, because as I'm talking, they can start putting the questions, because at the end, then questions they may forget. Now, what is an associate member? It has also been defined. The associate member that is defined in the Act is different from the way the associate member is defined in the bylaws. So once this is defined in the Act, that particular clause in the bylaw stands suspended. So please do not confuse. It stands suspended, that is no longer valid, and the Act supersedes it and Act is valid. The Act says that an associate is a husband. Now, very, very important to hear this, because it is otherwise going to cause some confusion. Associate is a husband, wife, father, mother, brother, sister, daughter, son-in-law. Now, son-in-law is a new addition. Previously, we used to have only daughter-in-law or unmarried daughter or unmarried sister. That has now been changed to, I repeat, husband, wife, father, mother, brother, sister, daughter, son-in-law, daughter-in-law, nephew, niece, and a person duly admitted to the membership of the housing society on a written recommendation of the member to exercise his rights and duties with his written prior consent and whose name does not stand in the share certificate. That means even if your name does not stand in the share certificate, and the share certificate has the name of the lady who is the wife, The husband can become an associate member. The father can become an associate member. The father-in-law cannot become. So it says husband, wife, father, mother. Does not include father-in-law, mother-in-law. Which means if the couple is living in a flat and the son is buying the flat in his name, then his father can be. But other way around, if the wife is buying the name in the flat, then the father-in-law is not going to be an associate member. So she can make her father an associate member, but cannot make the husband's father, although she's staying in the flat where the father of the husband is also staying. So this is something which one must understand. So I'll read again. Associate includes husband, wife, father, mother, brother, sister, daughter, son-in-law, daughter-in-law, nephew, niece, a person duly admitted to membership of the housing society on written recommendation, which means these persons, these relations have to get a NOC from the member in a particular format, which is called a written recommendation, and the rights and duties with prior consent. And the name of these persons need not stand on the share certificate, which means they don't get ownership rights. It is more like a power of attorney, semi power of attorney, which gives the right to the associate member to stand for election, to attend general body meeting, to correspond with society, and so on. Then we have the next one, which is joint member. Now, joint member and associate member have been distinguished. Previously, it was one associate member. Now, the new concept is joint member. Joint member is a person joining in an application for registration of housing society jointly and who holds shares, rights, and title of interest, but whose name does not stand first. The person whose name stands first becomes the member, first member, and then all the other persons who are joint in the agreement of purchase would then become joint members. Distinction between associate member and joint members. So if you have a right and title, you are a joint member, and you can have the order in which you want, which is the discretion of the owners. They can decide who should be first, who should be second, who should be third. The first person has to be ready to pay the maintenance because the first one undertakes that I shall be responsible to pay the maintenance. That takes care of the membership part of it. The third one, which is there, the associate joint, is provisional member. Now, provisional member is a new concept which has been introduced in the Act, does not appear in the bylaws. So in the bylaws, they have got two bylaws which talk about how to transfer membership if the member dies by making a nomination or by not making a nomination. There is a process. The process has been clearly defined. And also it says that if there is a nomination, then the name of the nominee should be put on the share certificate. It's very clear even in the old bylaws. But in spite of that, there were problems. In spite of that, the society used to create issues. So now the amendment has come in the definition, which says provisional member. A provisional member is admitted temporarily after the death of a member on the basis of a nomination till admission of legal heir or heirs as member of society. That means even if there's a dispute, if there is any disagreement, anything is there, society does not have to wait. If the name is there on the nomination, automatically by law, by an act of law, because now this becomes the part of the law, not only the bylaw, not the rules, but the main act, that provisional member is admitted temporarily after death of the member on the basis of the nomination. So if your nomination is there, then automatically by operation of law, you are entitled to have your name. You have to just put your application, show them this provision that this is the new act, and then please make me the member, and society has to make. If not, then of course you have to go to registrar for issuing directions that society is not following the act. And registrar will issue a direction. So it reduces the burden on the children or whoever is the nominee of going through a whole process of hearing. So that is where the distinction has come in. Now there is something which is called deemed member. Many people call up and ask, what is a deemed member? In law, there is nothing called deemed member. There is no such thing called deemed member. He is either a member or not a member. And if you are a member, you are either a member or a joint member or a provisional member. There is no fourth designation of a member. The word deemed member has come by a misread of section 22. Section 22 says that if you have made an application, no, nomination does not override the succession. I read before, is changed on nomination till admission of the legal heir as a member of the society. So the family will sort out as per succession who are the legal heirs, and then by virtue of that order, the society will convert the name to the name of the legal heir as appointed by an authority. I was now talking about the deemed member. There's a confusion and people say you can't be a deemed member, you are a deemed member. The section 22 is very, very clear. It says that if you have applied for membership and the society does not give you any response within 90 days or 3 months, you are deemed to be admitted as a member, not that you are deemed to be a member. So the word admitted has been entered and added in the act. So anyone who has made an application and he has filled the forms and he has paid the fee for the transfer and the shares and files the application with the society, and society does not respond within 90 days, he is deemed to be admitted, not the other way around, that he is admitted as a deemed member. So he is not a deemed member. He is a full-fledged member. And the act further says that in case of difficulty, the registrar's opinion is final, which means that whoever has the difficulty should approach the registrar. So if society has a difficulty, society should go to the registrar and not put the burden on the member, because society has defaulted in answering or giving the response within 90 days. So they should go to registrar and say that, please clarify whether so-and-so person is to be admitted or not. The registrar will take a hearing, call both the parties, and then pass the order. In the alternate, the person who is affected, that is the member who has applied, but society refuses to give him the share transfer, or refuses to put him on the election list, or refuses to put him in the form J and I register, also is the one who needs a clarification. So he will file an application to the registrar under 22 to issue a declaration that I am a member. So their declaration will come as against section 23, which deals with an appeal for membership. So there are distinctions. Now we come down, after having done the membership, we now come down to the other issues. What happens if a member does not pay his money? Because there was a 2002 circular issued by the ministry which says if you are a defaulter, you can't complain. Now that, but there were a lot of controversies, and thereafter I think it has been put in the back burner. Because if you have a problem, you have to go to registrar. And if society says that because you are a defaulter, we will not entertain any application from you, then you are denied your rights, which is under Article 19, that you have certain fundamental rights, and you may have a situation where you are a defaulter for no fault because certain charges are there, but society doesn't want to listen. And then the law says that if you have a problem on the billing, go to cooperative court, which many societies may do just to send you to court, and a member cannot afford it, so it remains a problem. So now the definition of defaulter has come a bit clearer, which says that a flat owner or an occupier, which means that even if you have a tenant occupying or you have somebody else occupying who has not yet been given a membership, and that membership is still being going for front and back like a ping pong, and who fails to pay the dues of the society within 3 months from the date of the service of the bill or the notice or due date of payment. Now we've got 3 headings there under defaulter. And we have got the first definition, which is defaulted, is the flat owner or occupier. Here we have a problem. We have many societies where the flat owner is not even a member of the society. So that has to be treated very carefully. That if a society member, a person who bought a flat, never became a member. That means if a building has got 200 flats and 99 has filled the forms, the 100th person hasn't filled the form of becoming a member. His name does not appear in the INJ register. His name does not appear in any of the documents. Technically, is not a member. But then there is another law which says that once a society is registered, the first meeting under 45 days has to be held to induct everybody as a member. So if the society does not induct, the fault remains with the then managing committee who did not induct everybody or inform the registrar. Because you can't have a building with 200 flats, 199 society members and one non-member. So this area also is something which is a huge problem. And the societies.
After many days it was raining.
So I may come back. And the flat owner or occupier. So if today the father dies, the son takes over, society has not transferred, he can still be sued under the section for collecting the society dues as an occupier. So that clarification is there in the act. Now we come down to what is the actual date, because when you give three options, that it should be within 3 months from the date of service of bill or notice or due date of payment, you may have societies which put different due dates. So whatever the due date, 90 days thereafter, you become a defaulter. So if the society is charging you annual payment and gives you a due date for 6 months, because there are some societies who give you one bill and say you can pay mid-month, mid-year. That means you will then become a defaulter if you don't pay 90 days after the 6th month. Sometimes you get quarterly bill, sometimes you get monthly bill. Now, very important that if you don't pay, you have to be issued a notice. So if you get a bill and 90 days you have not paid, before you become a defaulter, a notice has to be issued. So once the notice is issued, then 90 days from the date of the notice. Or the due date of the payment, if you don't pay, the notice is issued 90 days after the notice. So that clarification is there in the Act, but not in the bylaw. Now we come to the next item. What is the dues? I'm a defaulter for not paying the dues, but what is the due? The dues are also now defined in the Act. So if there's anything defined in the bylaw, one has to read the Act with the bylaw. But the Act puts the onus on back to the Act. It says the amount payable by a member or a flat owner. Now you see the distinction has come here. Flat owner, which means occupier, non-member occupier, to the society and demanded by the society. Now we have a confusion that if I'm not a flat owner, society doesn't issue me a bill. He issues a bill in somebody else's name. But I'm a flat owner, but I'm not a member. So these confusions have to be sorted out by different areas in the Act and the rules, which we will talk as we go along. But right now I'll restrict myself to the definition of dues. The amount payable by a member or flat owner to the society and demanded by the society by issuing a bill in writing. That means if a society does not issue a bill and just puts a list on the notice board, that is not a bill in writing. Now, most important, and such demand is based on the provision of the Act, rules, and the bylaws. So if there is something in the bill which is not as per the Act, rules, and the bylaws, then you don't have to go to cooperative court. You have to go to registrar and complain that what is put in the bill is violation of the Act, rules, and bylaws. The registrar should ask society to correct that particular anomaly. And in the bylaw, reflected. What headings can be taken for charging you is also written in the bylaws, which are clearly stated, which are not changed. So if you read the two together, you will be able to understand the meaning of the word dues. But as we go along, I will take the dues and the defaulter as a separate meeting because these are issues which are very, very common and I have to go into depth. The next definition that is there, which is different from the bylaw, is the word officer. Now we've got a word officer that has come in, which means any person Now, I've been using the word person throughout my talk, and I've not seen a single question coming in. What is the definition of person? So after I finish this, I will also explain to you what is a person, because there are changes in the definition of person as well. Officer means person elected or appointed by the society. Elected or appointed, because you may have a situation where society may appoint somebody, like a manager, who is also an officer. Means a person elected or appointed by a society to any office according to its bylaws and includes any office bearers, members of the committee, not only chairman, secretary, assistant secretary, deputy chairman, apart from those title holders, any member of the committee, manager, or any other person, by whatever name called, elected or appointed to give directions in regard to the business of the society. So when you go to the society and you give it to a manager and he accepts your letter and gives you a direction, he is also an officer. The reason for the word officer that has come because section 148 and 147 deal with offenses. So previously the managers were not covered. Now, or it was covered but not very clearly covered. But now it is very clearly covered that even managers would be liable to the penalties if they don't follow the law, which means very simply that if the committee tries to break the law and the manager joins in with the committee to break the law, then the manager is also culpable at the end of the day under this particular definition of officer. So it's very important that managers who may be online today in the hearing should know that they have a separate role to play and they also have an independent role to play and there are penalties on